Hello and welcome to this Gowling WLG TUPE Club webinar on pensions and TUPE, the tricky issues. I'm Siobhan Bishop from the Employment, Labour and Equalities team, and I'm joined today by Liz Wood, a director in our combined Human Resources Solutions team, who has extensive experience on advising on both employment and pensions issues and the difficult crossover between those two. And I'm also joined by Jenny Lewis, who is a Principal Associate in the Pensions team, who has particular expertise in public sector pensions and staff transfers from the public to the private sector. The presentation will last about 50 minutes with some time for your questions at the end. And before we just start, I have a few housekeeping points. So the webinar player has a few simple controls. The most important are the volume adjuster and the full screen option, which are in the bottom of the right hand corner of the player. There are also some tabs along the top which you can click on to access details of today's speakers and also the slides. You can ask a question at any time, and to do that, click on the Ask a Question tab, type in your question and then click Submit, and we will try and answer as many as we can in the time available. Finally, there is a poll tab. Don't worry too much about that. Towards the end of the webinar, a poll will automatically flash up on your screen, and we'd really encourage you to participate in that. And finally, if for any reason you can't see the current slide, just click on the Slide tab to get back to it. So I'd like to welcome Liz Wood, who is going to take us through what we're covering today.
Thanks, Siobhan. Well, how pensions should be dealt with when a TUPE transfer takes place is undoubtedly a complex area, and one which can easily trip you up if you're not aware of the potential pitfalls. Today's webinar is intended to help guide you through the legal minefield that is TUPE and pensions, to help you understand where to begin if you're dealing with the TUPE transfer, and understand where your obligations start and end. We're going to begin by considering why pensions are treated differently to other terms and conditions in a TUPE context. And this is important because it provides some context to what otherwise might seem to be a pretty unfathomable set of legal principles and rules. We'll cover the impact of the pensions exclusion found in TUPE, both for the transferring employee and the original transferor employer. And then we're going to focus in particular on the implications for the post-transfer employer of the transferred staff. What are the obligations to provide a pension once the transfer has taken place? What pension options are available to the new employer? What areas are unclear, and how can this be practically managed? Finally, for the last 15 minutes or so, my colleague Jenny Lewis will cover one of the tricky aspects arising from a particular type of TUPE transfer, that is, the transfer of public sector employees. Now, I'm sure that many of you will be very familiar with the circumstances in which a TUPE transfer, that is, a transfer of employees that falls within the Transfer of Undertakings Protection of Employment Regulations 2006, will apply. But by way of reminder, we're talking about either the sale of part or all of a business, so an asset rather than a share sale, or a service provision change, so shorthand for an outsourcing of services, a change of contractor, or an insourcing, so bringing the services back in-house. And whether TUPE applies is a very fact-specific analysis is required, and we're not going to cover aspects of that in today's webinar. But where you know that TUPE does apply, it has the effect of automatically transferring the employment of the affected employees from the old pre-transfer employer to the new post-transfer employer. And I like to think of this as the new employer essentially stepping into the shoes of the old employer. And the new employer becomes responsible for the vast majority of the rights, powers, duties and liabilities which were previously the responsibility of the old pre-transfer employer in relation to the transferring employees. So the new employer will be expected to honour pre-transfer commitments, so for example pay, holiday entitlement, benefits and other terms and conditions of employment. But stepping into the shoes of the original employer is a neat concept, but one which doesn't always easily work in practice. And when the original TUPE legislation was put in place, it was accepted that there were going to be certain benefits which were going to be particularly problematic for a new transferee employer to provide. The most obvious example of this is the provision of a pension by a transferor employer. Pension schemes, and in particular occupational pension schemes, are set up by an employer and contain specific terms relating to the employer's intended and treatment of its employees as members of the scheme. And it was recognised that it would be cumbersome for a new transferee employer to provide the same sort of pension scheme or the same benefit structure as was on offer before the transfer if the usual automatic transfer principles found in TUPE apply. In recognition of this, TUPE contains a broad exemption, and this says that rights, liabilities, duties and obligations that relate to the old age, invalidity and survivors' benefits provided through an occupational pension scheme and relating to transferring employees are not subject to the usual TUPE principles. So in other words, and in very broad terms, this means that where an occupational pension scheme is offered to transferring employees before a TUPE transfer, the new employer has no obligation to continue to provide or replicate that arrangement. And this is subject to some caveats, and we'll come on to consider those in a little later. So if you're dealing with the TUPE transfer of some incoming employees, the first point of distinction to get clear in your mind is whether the transferring employees are offered occupational pension scheme benefits or personal pension scheme benefits. And the type of scheme on offer before the transfer date isn't always straightforward. Don't assume, for example, that because a pension scheme is automatic enrolment compliant for Pensions Act 2008 purposes, it will be one type of scheme or the other, because in our experience both occupational and personal pension schemes are regularly used as qualifying automatic enrolment pension schemes. And it's also worth adding that I think 10 years or so ago it might have been fair to say that occupational pension schemes were becoming less common, with so many employers closing those schemes. But actually I think that's less true now, because occupational pension schemes, often in the form of master trust arrangements, are being chosen frequently by employers to discharge their automatic enrolment duties. So how do you identify an occupational pension scheme? Well, there is a very technical definition which is found in the Pension Schemes Act 1993, but practically you're essentially looking for a scheme that's set up by an employer to provide retirement benefits for its employees, and it must have its main administration in the UK. It's usually going to be a trust-based scheme, so you're looking for probably a dusty trust deed and rules. It often will provide defined benefits or final salary benefits. That's certainly true for the very traditional older occupational pension schemes, but not always. And occupational pension schemes may well also or solely provide defined contribution benefits, and that's particularly true of master trust arrangements. And some of the very common master trusts that you see in place, so for example the Nest scheme, the Now Pension scheme, these are all types of master trusts which are occupational pension schemes. So what other pension schemes are out there? Well, personal pension schemes don't form part of the pensions exclusion found in TUPE, and these are pension arrangements made directly between the employee and the provider, usually an insurance company, so the Legal and Generals, the Scottish Widows of this world. So they're not specifically set up by an employer to provide benefits for its own employees. And in this case, rights and liabilities associated with the personal pension scheme do transfer with the employee's employment, in line with standard TUPE principles. The most obvious impact of this would be that any commitment made by the pre-transfer employer to make a certain level of percentage contributions to a personal pension scheme or a group personal pension scheme would be an obligation which the post-transfer employer has to continue to provide following the TUPE transfer. So for example, if you see that a pre-transfer employer committed to an unusually high level of contributions to a personal pension scheme, for example 10%, 15% of pensionable pay, the post-transfer employer would be required to continue with this obligation following the transfer. So what is the impact of the pensions exclusion where an occupational pension scheme was on offer to the transferring employees immediately before the transfer? Well, the transferring employee won't have the benefit of ongoing membership of their pre-transfer occupational pension scheme. And as a starting point, that could result in a significant reduction in the amount of pension he or she was expecting had he or she remained in employment up to retirement, especially if the pre-transfer scheme on offer provided defined benefits. The employee at the point of the transfer becomes a deferred member of that occupational pension scheme, and their deferred pension remains payable from their previous employer's pension scheme. And the transferor, in turn, remains responsible for the funding and the liabilities in respect of that old occupational pension scheme, including insofar as it relates to the transferring employees. Meanwhile, the transferee employer doesn't assume responsibility for the scheme. it's funding or providing benefits for the transferring employees. But that's subject to a very important caveat. Importantly, the TUPE pensions exclusion is not a wholesale blanket exclusion. The pensions exclusion in TUPE is, on the one hand, very wide. It refers to rights, powers, duties or liabilities arising in relation to a transferring employee's employment in connection with that occupational pension scheme. But importantly, I mentioned a few minutes ago that this is only to the extent that it provides old age, invalidity or survivor's benefits. In layman's terms, these are the rights you'd expect to be provided in a defined benefit pension scheme. So rights arising on the member reaching a certain age, so that they're retiring at 60 or 65, a pension being payable in circumstances of the member's ill health, or, for example, on the death of a member, a spouse or civil partner's pension being payable. And these rights remain with the seller or transferor because of the pension scheme exclusion. But the fact that the pensions exclusion in the TUPE regulations specifically refers to old age, invalidity or survivor's benefits begs the question, could there be other rights in the occupational pension scheme which fall outside the pensions exclusion and therefore are liable to transfer? And the short answer is yes. And this was clarified as a result of two decisions we had in the early 2000s, which made it clear that certain occupational pension scheme benefits in final salary schemes might not form part of the TUPE pensions exclusion. So contingent rights, so rights that might not obviously be payable unless certain circumstances arise, are liable to transfer to a new employer following a TUPE transfer. And these two rights are pension scheme benefits payable on an employee's redundancy, and that was made clear by the BECKMANN decision, which is an ECJ decision from 2002, and also pension scheme benefits payable on the early retirement of a member, and that was in the Martin decision, also by the ECJ back in 2003. And in both those cases, the ECJ's rationale was that neither of these benefits are payable on the member reaching old age, or in the event of the member's ill health, or on the member's death. So essentially, they fell out of the exclusion. And these rights are generally referred to as BECKMANN rights. And whether these rights exist will largely depend on a good hard look at the rules of the pension scheme in question, preferably with a cold towel over your head, because the wording of these rules can be complex, archaic, and hard to interpret. So what does this mean for the transferee employer? Well, there's no doubt that this can mean a huge potential liability for a new employer, particularly if it knows it needs to make redundancies or create efficiencies, be that immediately following the TUPE transfer or many years after the event. The possible extent of the liability which a new employer might assume in relation to these BECKMANN rights was a grey area for a number of years following the BECKMANN and Martin decisions in the early 2000s. In particular, there were real question marks around whether a buyer or transferee would have to assume responsibility for the full cost of providing a redundancy or early retirement pension from the moment it was payable until the member's death. Fortunately, we've had some additional clarity provided over recent years over the extent of the transferee's obligations to provide these types of benefits, particularly in the form of the Procter & Gamble High Court decision of 2012. And this was all about the sale of Procter & Gamble's European tissue towel business to a company called SCA. So the key clarifications that we know now are the following. Firstly, that only rights which a transferee might be liable for under the BECKMANN principles are the benefits which are payable before normal retirement age. So from the date the redundancy pension comes into payments up to the scheme's normal retirement age. Secondly, the new employer is only liable for the value of the enhancement to any such pension scheme benefits, so the amount in excess of the normal deferred pension. And this is important because it essentially caps the transferee's liabilities in respect of the pension. The pre-transfer employer remains responsible for funding and paying the bulk of the employee's pension in the form of the member's deferred benefits. If the benefit is subject to a discretion under the old scheme, so for example the employer has to consent to the redundancy or the early retirement pension being payable, this discretion or this consent provision transfers to the new employer along with the contingent rights. So essentially this goes back to the new employer stepping into the shoes of the old employer. And this is a really helpful clarification because it essentially means that the new employer could feasibly decline to give that consent to the redundancy payment being made in the first place, subject to a reasonable expectation of being fairly treated. And finally, connected to the first point, any benefits payable from normal retirement age, including where a pension is already in payment, are old age benefits and therefore are not the responsibility of the transferee. So a right can change in nature from one form of benefit to another. This means a benefit might, for example, be a redundancy pension when it's first paid, when the member is made redundant, but once that member reaches normal retirement age, it's become an old age benefit. And so under the pensions exclusion, it then no longer becomes something which the transferee has any responsibility for. There's no doubt that, despite the helpful clarifications we've had on the extent of a transferee employer's liability to provide redundancy and early retirement benefits, this remains a really problematic area with no simple solutions. In particular, whilst the transferee's liability has undoubtedly been limited by the Procter & Gamble decision and clarifications, there still remain a number of unanswered questions. In particular, knowing at the point of the transfer exactly how much the Beckman rights contained in a transferor's pension scheme are worth in respect to the transferring employees. This will depend on a number of factors, including the number of eligible employees, their age, their salary, their length of service, but also the likelihood of them actually being made redundant or eligible for early retirement following the transfer. And secondly, there's a real question for transferees around how these rights can be provided. The transferee, as I've mentioned, has no obligations in relation to the pre-transfer pension scheme. That remains with the transferor. So how is a transferee supposed to provide these kind of benefits absent its own defined benefit pension scheme? There aren't any simple solutions to that, but there are ways that you can protect yourself as a transferee in anticipation of a TUPE transfer. The first way is by doing due diligence on the pre-transfer pension scheme. So is there a final salary occupational pension scheme on offer before the transfer date for the transferring employees? If so, check for clauses giving right to enhanced pensions payable on redundancy or early retirement, particularly where these are described as early retirement for reasons of service efficiency of the employer or other such wording. And if such clauses exist, check whether the pensions payable are unreduced despite the fact that they're paid before normal retirement age, because that's really flagging that there's going to be an additional liability for you as a transferee. You may well want to get specialist input if you're looking at a pension scheme and you think these rights exist. Not least because as a transferee employer, there might be some pretty significant costs associated with providing these pensions if you are found to be liable under TUPE to provide them. And it's worth mentioning that in the Procter & Gamble case, the reason that this got taken to the High Court was because the parties were fighting over an estimated liability of £19 million of potential Beckman liabilities. So it was a really big issue for them to sort out. As part of your due diligence, also check whether there's a consent provision, so that control mechanism I was talking about for the employer to agree or decline to pay the redundancy pension, because that can be a really invaluable gatepost to control when the Beckman rights actually crystallise. If rights exist, seek indemnity protection in the business transfer or outsourcing agreements, particularly essential if you want to get some actual financial compensation from the seller or transferor in respect to the Beckman rights arising. And following these rights might be challenging, so you may well need actuarial input on assessing the value of those rights. It's also possible that you might be able to cut a deal with the affected employees. As I mentioned, we don't have an absolute answer as to how these benefits should be provided by transferee employers, but it's possible, for example, in the context of an actual redundancy situation, that the Beckman rights are tied up as part of settlement agreements to compromise out the Beckman aspects. And it's possible to do this because there will be dispute as to the amount of the Beckman rights that might be a liability of the transferee. So you have to be very careful about doing this, but I have seen that done in practice on occasion. What's more difficult is to reach settlements to compromise out those Beckman claims when you don't actually have a redundancy situation that you're actually looking at for those employees. There's also another aspect to consider in terms of pensions exclusion, which is don't assume that because there's a pensions exclusion that you don't have to comply with the TUPE consultation obligations. The transferor must inform appropriate representatives in sufficient time to enable consultation. It's a standard accepted common practice under TUPE, and the transferee has obligations to tell the transferor of any measures it plans taking following the TUPE transfer. And any pensions change or measure being proposed should form part of the usual TUPE information and consultation obligations. And that would include changes to contribution rates of pension schemes or even administration charges, because it's been quite clear that the TUPE case law around measures is that very small changes should still be part of the information and consultation process. Penalties exist for failure to inform and consult, and this could be up to 13 weeks' pay per affected employee. And this is joint and several liability for any failure to inform and consult between the transferor and the transferee. It's also important to understand that there may also be separate pensions consultation obligations and a possible regulator fine of up to £50,000 for failure to consult under those pensions consultation regulations. Moving on, there's also a separate obligation for transferees in relation to the minimum level of pension provision that transferee employers must provide to transferring employees where they were offered occupational pension scheme benefits immediately before the transfer. This was originally put in place in 2005 in recognition of the fact that otherwise transferring employees who had occupational pension scheme rights before a transfer could simply lose those rights in terms of future service benefits at the point of transfer, with no obligation on the transferee to offer any kind of pension benefits from that point onwards, subject to the Beckman rights I've talked about and any public sector obligations. And these protections come from the Pensions Act 2004 and the Transfer of Employment's Pension Protection Regulations 2005, which I'm going to refer to as TEP. And these TEP pension protections bite where there's a TUPE transfer. Immediately before the transfer, the seller or transferor operates an occupational pension scheme where the transferring employee or employees are members of the scheme, so either active members or their prospective members, so eligible to join. And if it's a money purchase or defined contribution occupational pension scheme where the employer is required to contribute, so that might be that they're either contractually committed to contribute or it's an automatic enrolment scheme where they're required to contribute in that sense. Where the TEP regulations arise, where people were offered occupational pension scheme benefits before the transferee has a choice to provide either defined benefit pensions or defined contribution pensions. And it doesn't have to be the same type of benefits as was on offer before the transfer. Most commonly, a new employer will simply meet this obligation by offering the transferring employees defined contribution or money purchase benefits through an occupational pension scheme or stakeholder scheme from the date of the transfer. And in that case, the transferee has an obligation to either match the employee's contributions up to a maximum of 6% of pensionable pay, or to simply match what the pre-transfer employer was making to the scheme. And that's been a new change introduced to TEP in recognition of the dual obligations of TUPE and automatic enrolment. Alternatively, the defined benefit option could be put in place. But in my experience, it's very, very unusual now for an employer to offer DB benefits to satisfy TEP obligations, unless it's either already got an open defined benefit arrangement for existing staff, or it's got some sort of separate contractual obligation to do so. So, for example, it's a public sector outsourcing. Unusually, in the context of TUPE, which generally prohibits contracting out of its provisions, it is possible for a new employer and the transferring employees to contract out of these TEP protections and agree something different. The new automatic enrolment obligations add an additional layer of complexity because the two protections, so the automatic enrolment obligations under the Pensions Act 2008 and the TUPE protections under TEP, must both be met by the new employer. This means that the due diligence process I've described for establishing what kind of pension provision was on offer to the transferring employees immediately before the transfer remains essential, But the transferee now has the unenviable task of ensuring that both obligations are met. So at the moment, that means that under automatic enrolments, there is a minimum 1% employer contribution and a worker contribution of 1%, but over time that's going to increase to an overall 8% of qualifying earnings for automatic enrolments, which must be complied with alongside those TUPE obligations I've described, so the up to matching 6% or matching what the transferor was paying before the transfer. So this is just a short case study to exemplify this. So you might have a transferee employer offering automatic enrolment schemes with those minimum contributions to meet its current requirements. You have a transfer of employees into the business, and those employees before the transfer date made 4% contributions to the defined contribution occupational pension scheme. So there's an occupational pension scheme in place. That means that the TEP requirements must be satisfied by the transferee. And the transferee can choose to either match those employee contributions up to 6% of basic pay, so that would be the 4% contributions, or it needs to match the pre-transfer employer contribution. So that might be 4%, it might be less, it might be the 1% that they're required to comply with for automatic enrolment purposes, just like the transferee in this example. What if the transferee wants to make changes to its pension provision for TUPE protected employees? And I'm primarily thinking about benefits which are transferred under the automatic transfer principle, so for example personal pension scheme rights or possibly life assurance rights. Changing TUPE protected transferred pension obligations is problematic, and this is the same for many terms and conditions of employment in relation to TUPE transfers. This goes back to the principles established in the Daddy's Dance Hall case, where it was clear that despite employees ostensibly agreeing to terms and conditions changes, those changes could later nonetheless be found to be void for being in connection with a TUPE transfer. So it is very difficult to assume that you can simply change personal pension scheme rights or liabilities following a TUPE transfer as a result of these TUPE protections. So a lot of care needs to be taken on that front. I've also mentioned possible variation to Beckman and Martin rights and the possible use of settlement agreements, but again a lot of care needs to be taken, and in my experience it tends to be in a scenario where redundancy is actually on the cards rather than as part of an overall redundancy, as part of an overall harmonisation exercise. So in summary, I've talked about the importance of due diligence in relation to understanding what the pension liabilities are before the transfer. This is absolutely key. It really helps you as a transferee to understand what your obligations might be following the transfer, and to assess what various obligations you might have, be that through legacy, defined benefit occupational pension schemes, to provide Beckman or Martin rights, or as a result of the TEP protections, but also thinking about the other obligations as a result of automatic enrolments, duties found under the Pensions Act 2008. And then you obviously need to think about your options for managing those more problematic obligations.
Thank you very much, Liz. And just a reminder that if you have any questions on any of those issues or anything else that comes up during the webinar, please do feel free to ask those. We've had a number come in already. So I'm now going to hand over to Jenny, who is going to concentrate on the final tricky issue for today, which is how TUPE applies on a public sector transfer. Jenny.
Thanks, Liz. Thanks, Siobhan. Hello, everyone. I'm going to spend about 15 minutes today on another one of the tricky TUPE issues, that is TUPE transfers from the public sector. So I'm going to cover why TUPE transfers from the public sector are different with regard to pension rights, when you might find you're dealing with a TUPE transfer of public sector staff, the extra protections that apply to those staff, what those extra protections are, and what are some of the practical issues you need to keep in mind. So we've heard from Liz that TUPE does not protect the majority of pension benefits, and there is uncertainty over what benefits are protected by TUPE. This was an unsatisfactory position for the government with an agenda to outsource public services, so led to extra protections being put in place to fill the TUPE gap in relation to pensions where staff transfer from the public sector. So this started with the Fair Deal guidance in 1999, and we'll come on to look at the current pension protections that apply where there's a TUPE transfer from the public sector. It's also important to keep in mind about when you might be dealing with a staff transfer from the public sector. Some scenarios will be obvious, like the first time a public service is outsourced to the private sector, or the first time that a service contract is retendered. However, in other situations, it might be less obvious to find that you have historic public sector staff amongst the transferring workforce. For example, the purchase of a business which was historically a function of a local authority. We regularly provide support on corporate transactions where the due diligence shows up ex-public sector employees amongst the transferring workforce, where they wouldn't necessarily expect to be found. The entitlements for such staff will then require further investigation, but it is important to do that due diligence first so you know who you are dealing with and what further questions to ask. This slide shows the extra protections that apply for staff who are compulsorily transferred from the public sector or did transfer from the public sector and are now the subject of an onward transfer in connection with the provision of the outsourced service. Fair Deal, introduced in 1999, was a non-statutory policy that required staff who had been transferred from the public sector to be offered either access to the applicable public service pension scheme where that was possible, or to be provided with an occupational pension scheme that was broadly comparable to the public sector scheme they'd left behind. In relation to their past service benefits, Fair Deal required that staff were offered a transfer of their accrued benefits to the new arrangement on a day-for-day service credit basis. So many of you may have company occupational pension schemes which are broadly comparable to various public service pension arrangements and provide different benefits in different sections depending on when the staff transferred and what scheme they transferred from. Now, new Fair Deal came into effect for transfers after October 2013, and it's also a non-statutory policy. And I'll come on to look shortly at who is covered by this and what the requirements of it are. The Best Value Direction of 2007 continues to apply to best value authorities, and we'll look later at what might replace this in the future. So new Fair Deal applies directly to central government departments, agencies, the NHS and maintained schools, which includes academies. It also applies to other parts of the public sector under the control of government ministers, where staff are eligible to be members of a public service pension scheme. The new Fair Deal guidance does not apply to best value authorities, which includes local authorities. They're covered by the direction. Fair Deal and new Fair Deal also do not cover TUPE transfers from housing associations unless there are transferring staff who already have Fair Deal protections as a result of their original transfer from a local authority. New Fair Deal does also not apply to other employers that might be considered to be part of the public sector, but it is open to those employers to adopt the new Fair Deal principles. This might apply to certain charitable bodies, for example, whose staff participate in the LGPS. We'll now move on to look at what pension protection is required under new Fair Deal. So new Fair Deal applies when staff are transferred from the public sector to an independent contractor. When new Fair Deal applies, that contracting authority should ensure that the contractor provides them with access to the appropriate public service pension scheme for so long as they continue to be employed on the transferred service or function. The contract for service should specifically require this, and the contracts of employment of the transferred staff should also provide that they have a right to continued membership of the public service pension scheme. This means that the rights are ultimately directly enforceable by the staff. Contracting authorities also need to ensure that staff who have been transferred from the public sector under the new Fair Deal policy are provided with continued access to the relevant public service scheme on any subsequent compulsory transfer while they continue to be employed on the contracted out service. This includes any transfer to a subcontractor. On any subsequent transfer, it's also important that the contracts of employment continue to reflect the right of the individual to membership of the public service pension scheme, so they can enforce this right against the new employer. So the previous slide covered the position for staff who transfer under new Fair Deal. However, there are many staff who transferred before the new Fair Deal took effect and to whom old Fair Deal applied. On the retender of a contract to which the principles of old Fair Deal applied, contracting authorities should require the bidders to provide the eligible employees with access to the appropriate public service pension scheme whilst they continue to be employed on the contracted service. This is the default position, and the appropriate scheme will normally be the scheme that the staff would have been in if they had remained in the public sector and had not been transferred out. If, however, there are particular circumstances which mean that to require access to the public service pension scheme would mean that the contracting authority was not treating all bidders equally and therefore was not complying with its procurement obligations, then it may permit the incumbent contractor to have the option of providing a broadly comparable pension scheme. This could potentially be where the costs associated with the bulk transfer are very high, or where the employment contracts give employees a right to membership of the broadly comparable scheme and the incumbent contractor is unsuccessful in obtaining consent to vary those contracts. In these exceptional circumstances, the contracting authority may permit all bidders to offer the option of a broadly comparable scheme as well as access back to the public service pension scheme. However, in our experience, these exceptions will be very rare, and the default of returning to the public sector scheme will be the normal requirement. The most complicated element of new Fair Deal is the arrangements for a bulk transfer from an incumbent contractor's broadly comparable scheme back to the appropriate public service pension scheme. New Fair Deal requires that staff moving back have the option of having their accrued rights protected by a bulk transfer arrangement. This will require a transfer payment to be made by the transferor scheme to the receiving scheme. In terms of the mechanism for this, all existing contracts should deal with exit provisions and include an enforceable obligation on the employer to allow for an onward bulk transfer to the new employer's broadly comparable arrangement. It is the standard position for the bulk transfer terms on an outward transfer to be no less favourable than the bulk transfer terms for the original transfer in. If the transfer payment paid out by the trustees of the comparable scheme is less than this, then it is usual under the exit provisions for the employer company to be on the hook for this shortfall. The contracting authority should have undertaken the necessary preparatory work before issuing the invitation to tender to bidders, and should be able to provide details of the onward bulk transfer terms to bidders, along with details of the service credits to be provided in the receiving scheme. If the bulk transfer is considered insufficient to meet the liabilities in the receiving scheme, then the bidder is required to identify this price adjustment or shortfall in its bid. The contracting authority will usually be responsible for this shortfall. If you're dealing with a TUPE transfer of staff from a local authority, then it's the best value staff transfer direction that applies. Unlike Fair Deal, this is legally binding and requires pension protection where local authority employees are transferring in connection with the outsourcing of a service. The service contract must provide that the contractor secures pension protection for each transferring employee, and that the provision of pension protection is enforceable by the transferring employee. Pension protection will be secured if after the transfer, the transferring employee has rights to acquire pension benefits that are the same as or broadly comparable to or better than the rights he had or had the right to require as an employee of the authority. Now, pension protection under the direction is only required for future service. There is no requirement to provide for a transfer of past service benefits. The requirement to provide access to the appropriate public service scheme under New Fair Deal is met in the NHS pension scheme by the contractor entering into a New Fair Deal direction. This is a standard legal document and provides for eligible employees to be able to access the NHS pension scheme. In the civil service pension scheme, there is a participation agreement to enter into, which sets out the terms by which the contractor would participate in the scheme as a scheme employer. In relation to the local authority, the requirements of the direction can be satisfied both through the contractor entering into an admission agreement or by providing or establishing a broadly comparable pension scheme. It's important to remember that the requirements of New Fair Deal and the direction are high-level principles only, and to be binding on the contractor, they need to be imposed through the service contract. If it's not covered in the contract, then there is no requirement on the contractor under New Fair Deal. The wording of pension schedules covering the requirements of Fair Deal have been around now in pretty standard form for a number of years. And in some cases we're finding that standard drafting is being used slavishly without really attention to the specific circumstances of that particular transfer. So make sure you read the contract, and if it doesn't seem appropriate or doesn't adequately address, for example, the bulk transfer process, then don't be afraid to amend or to challenge the wording. So what about the future for transfers from local authorities? Well, the Department for Communities and Local Government revealed its long-awaited draft provisions last summer. These were intended to give effect within the local government sector to the New Fair Deal principles. It certainly would make sense for the local government sector to have the New Fair Deal principles applied to it, rather than the currently different and separate treatment under the Best Value Direction. The amendment regulations proposed the use of the existing admission agreement mechanisms and introduced a new category of employee called a protected transferee. However, in a number of areas the proposals were inconsistent with the requirements of New Fair Deal. For example, the definition of protected transferee was wider and included not just core LGPS employers like local authorities, but also extended protections to employees of existing admission bodies, who would not necessarily be covered by New Fair Deal or by the direction. The responses to the consultation highlighted these issues and other problems with the detail of the drafting. As a result, DCLG have had to go back to the drawing board. They've not formally responded to the consultation, but we understand will instead issue a further consultation. When this will be, however, is another issue, as we're informed that DCLG are currently understaffed with resources being directed to Brexit instead. So in this final section of the presentation, I'll look at some of the practical issues that we see arising in the context of TUPE transfers from the public sector and on the application of New Fair Deal. Firstly, poor quality data. As Liz has mentioned, obtaining adequate data on the transferring staff is potentially a difficulty connected with all TUPE transfers. However, the potential costs associated with poor quality data could be higher where there are public sector staff transferring, and it's really important to make sure that you have all the information as to what scheme the staff are members of as soon as possible in the bidding process. If the information provided by the authority or the incumbent provider is not sufficient, then it is reasonable in a bid to include assumptions and to reserve the position until adequate data is provided. Redundancy benefits are also a complexity of transfers from the public sector because of the comparatively generous benefits provided by the public service pension schemes. As Liz has described, the rights to redundancy and early retirement benefits will transfer under TUPE, and in addition, where there's a transfer from the public sector, there is often specific wording included in the service contract to enshrine this principle so that the contractual position is clear. It's important to make sure that the participation regime for that particular scheme allows access to the public service pension scheme redundancy arrangements. If it does not, then alternative arrangements will need to be made in line with the requirements under the contract. If a broadly comparable scheme is used, then redundancy benefits are outside of the GAD's, the Government Actuaries Department's broadly comparable assessment, and so alternative arrangements will also need to be made in that circumstance. Redundancy rights need to be properly understood and costed, particularly where redundancies are possible after the service transfer. It may be possible to negotiate an indemnity from the contracting authority in respect of such costs. It's also important to make sure that the correct terms are being applied when calculating redundancy benefits and costs. For example, redundancy benefits through the Civil Service Compensation Scheme were amended from November 2016. However, for staff who transferred from the public sector before those changes, the terms of the previous compensation scheme will continue to apply. Whilst the participation regime has made the process much simpler than the requirement for a broadly comparable scheme, it is still important to make sure that all the associated costs and obligations are understood. For example, the employer contribution rate will be the same for the participating employer as it is for the public sector body, but it is possible that those rates could increase during the term of the contract, and you should consider how to deal with that. It's also important to make sure that you understand the further costs that are going to be met by the admitted body. For example, administration charges or costs in respect of commission services or additional contributions that will be required where members retire early. As an admitted body, there's also reporting and monitoring requirements, and you should make sure that there are adequate systems in place to comply with these. For example, monitoring how much time staff spend delivering the outsourced service to make sure that they continue to be doing it for at least 50% of their contracted hours. Liz has talked about the interaction between TUPE and automatic enrolment, and where there's a transfer of public sector staff, then this is equally important because, again, it could mean additional costs for the new contractor when staff who had previously opted out of membership of the public service scheme are automatically enrolled following the TUPE transfer. It may be possible to put in place mechanisms to provide for an alternative and cheaper automatic enrolment scheme. However, you will need to continue to keep the option of joining the public service pension scheme open if those staff request it and meet the other eligibility criteria. We've talked already about bulk transfers, and they do really continue to be a particularly tricky area. The significant amount of preparatory work that needs to be done by the authority before it goes out to tender can be patchy. There's also a significant amount of work to be done by the incumbent contractor and its broadly comparable scheme when preparing for a retender. Employers need to make sure they're aware of the shortfalls that may exist if the bulk transfer from the broadly comparable scheme is insufficient. There's also recently been a new policy note issued by the NHS in relation to bulk transfers, and it is possible that these same policy guidelines could be applied to the other public service pension schemes. Finally, timing continues to be an issue, and it's important as ever to make sure that there is good communication between commercial bid teams, HR teams and the pensions teams in an organisation. The level of engagement and resources from the public service scheme administrators also seems to vary, and therefore it's important that they're involved and engaged as early in the process as possible. That concludes the issues that I'm able to cover in the time allowed today, but if there are particular topics in connection with TUPE transfers or transfers from the public sector in particular that you'd like to know about, then please let us know through the feedback tab at the end of the webinar.
Thank you very much to Jenny for that overview of what is clearly a very complex area. We're now onto the poll, and that will be flashing up on your screen, which is a time for us to ask you what you have experienced in your day-to-day work. And what is the trickiest pensions issue which you have faced on a TUPE transfer? So a number of options. A, is it dealing with Beckman-Martin issues? B, harmonisation issues? C, public sector transfer obligations? D, the interaction between the TUPE protections and the automatic enrolment protections. So if you want to click on which you have found to be the most difficult area, we're getting responses coming in already. And while you're just having a think about that, there's a quick reminder that there is still time to ask a question, and we'll be coming on to those straight after the results of the poll. So just a couple more seconds for you to let those last clicks come through, and then we'll push the results out now. So, it looks like the largest category, 40%, is a public sector issues. And we did discuss this before and wonder what the outcome was going to be, and that was Jenny's bet. But there are a number of you who do find the other areas difficult to deal with as well. So thank you for sharing that, and that's an interesting outcome. We now have time to move on to the questions that have come in.
I've actually had one in. We've got a number come in. So
Okay,
I'll
Liz,
yeah.
yes.
So there's one question about common options that we've seen for a transfer of employees where there are early retirement or redundancy benefits. So we're talking about Beckman and Martin rights in a scenario where the transferee doesn't have a link to that deferred pension scheme. It's a really good question. And it goes back to the point that I was making around there isn't really a practical solution that the case law or the legislation